Hi, welcome to the video. This is Vivek Jain and I'm going to be presenting upon preventive action by the police. So preventive action by the police is covered under CRPC Chapter 11. Section 149 to 153 covers the provisions that provides the police officers the ability to arrest before the cognizable offense is happening. So, police to prevent cognizable offences is covered under Section 149. It states that a police officer may interpose for the purpose of preventing and shall, to the best of his abilities, prevent the commission of any cognizable offences. So, basically, this section provides the power to police officer to prevent any cognizable offence from happening. Section 2 of the CRPC defines the cognizable offences that are there. A person found doing cognizable offences can be arrested without a warrant or without the permission of the magistrate. Next up, in section 150, there is a provision regarding the acquisition of information of design to commit cognizable offences. This section states that every police officer, on receiving information about a particular design to commit any cognizable offense, shall communicate such information to the officer whom he is subordinate to. That means if someone is working under the SHO, State House Officer, he must inform the SHO about any information or any procedure that he may found of committing a crime. So next up we have arrest to prevent the commission of cognizable offences. So according to section 151, if a police officer has knowledge of design of commission of any cognizable offences mentioned under 150 that is not yet been committed, he may arrest without the orders from magistrate and without a warrant to the person so designing if it appears to such officers that the commission of the offence cannot otherwise be prevented. So subsection 2 of this section allows the only allows the custody of such person arrested to be under a period of 24 hours. Further custody shall require the permission or the presentation of the accused in front of the magistrate of the district. Prevention of injury to the public property. So prevention can also be done to prevent any injury to the public property. According to Section 152 of CRPC, a police officer may interpose on his own if there is an attempt to incur injury on public property, whether movable or immovable. Immovable, that doesn't matter. To remove injury to any public landmark, or to remove or injure any body or other mark used for navigation. The term public has been defined under Section 12 of the Indian Penal Code. Now, Section 153 deals with the measurement of weights and measures in shops or multiple trading centers or grocery stores where products are sold by measuring in hand. So, any officer in charge of a police station is empowered to conduct or initiate a search in any such area where he has the suspicion that a false weight or measuring technique has been made or sold. The main condition for this is the shop or grocery store or business must be conducted in the jurisdiction of the police station that he is in charge of. Now, there are certain possible misuses of preventative action. The following case of Neelabati Behra versus to State of Odisha and others narrates the story of a victim that was arrested by the police for a non-cognizable offense. Later on, next day, his body was found on rail tracks. So the police gave a clarification that the victim ran away from their custody and maybe may got hit by the train. The district court didn't find any valid reason or proof of suitable investigation and search for the victim, so they gave the verdict in favor of the victim. The Supreme Court awarded a compensation of 1.5 lakh to the mother of the deceased and ordered a sum of rupees 10,000 to be paid to the Supreme Court Legal Aid Committee. Also, the Supreme Court directed the state of Odisha to initiate criminal proceedings against those who were involved in the death of Suman Behra, the victim in this case, including the police officers and other people that were involved.